Hey everybody, Dr. Phil here. So this is going to be a video on providing equal employment opportunities and a safe workplace. With no further ado, let's jump right into it. So the first thing we're going to discuss in this video is regulation of human resource management. How is HRM regulated? You may have seen this before because this is you'd sort of see this in a law class, a legal class. The legislative branch, the executive branch, and of course the judicial branch. We think of these as like the separation of powers, excuse me, that most developing countries have in order to provide checks and balances, as we call it. So the legislative branch has enacted a number of laws governing HR activities and have usually been in response to perceived societal needs. So, well, that's the same with most laws, right? Like something happens, and then they say, okay, we really don't want people doing that, and they legislate accordingly. The executive branch includes regulatory agencies that are responsible for enforcing the laws passed by Congress, and the judicial branch influences employment law by interpreting the law and holding trials concerning violations of the law. And of course, that would be the judicial branch, excuse me, would be where the first precedents in all areas of law, but certainly in HR law, will of course be set. So let's talk a little bit about the Equal Employment Opportunity. So we can think about the EEOC, Equal Employment Opportunity Commission. So the idea of EEO, as I will abbreviate it, is the condition in which all individuals have an equal chance for employment. So government regulates HRM to ensure EEO, and again, you heard me mention the EEOC. That is the sort of the primary conduit and the primary mechanism by which governments affect that. It's also been done through constitutional amendments. We'll talk a little bit later in the video about like the 14th Amendment, for example. Um, Various legislation, some at a federal level, some at state levels, executive orders, and then of course court decisions, which often then set, you heard me use that term, precedents, often set precedents. So there, yeah, constitutional amendments. So let's talk a little bit about the 13th and the 14th Amendment. So the 13th Amendment abolished slavery in the US, and this has been applied in cases where discrimination has involved symbols and or incidents of slavery. The 14th Amendment forbids states from taking life, liberty, or property without due process of law. And again, the idea of due process is just, like everybody has a right to a speedy trial, for example. If somebody's accused of doing something, then they have a right to, confront their accuser, for example. These are all things that are part of due process in law. The 14th Amendment also prevents states from denying equal protection of discrimination. It also applies to decisions or actions of government or private groups whose activities are deemed government actions. So here's a kind of a case in point for you. So we'll just kind of read through this together, just kind of give you an idea as to how this works. This is one example of a law, the Uniformed Services Employment and Re-employment Rights Act. So you can kind of guess from the title, what this means. Somebody's going to go off and fight for their country, then most people would agree when they get back, they have a right to their old job back. So Eric Miller, an Army Reservist sergeant, was deployed for service with the 363rd Military Police Unit in Iraq for over a year. When he returned to the States, he was able to resume his job as an elementary school teacher thanks to the 1994 Uniformed Services Employment and Re-employment Rights Act. The Act requires employers to re-employ service members in the job they would have held if they had not left to serve in the military. And think about why that's important, because that's encouraging people, and certainly reservists as well to, most reservists, of course, hold regular jobs, that they don't have to fear that, they're going to leave, go get deployed overseas, go do some sort of extensive training, come back, and, their job has been filled by somebody else. Now, obviously, the employer will probably fill it with a temporary person, or maybe they'll job share it out. But the job, pay, etc., will still be there for that individual, as it should be, upon their return. All right, so let's talk a little bit about the government's role in providing for equal employment opportunity. You heard me mention earlier that it kind of touched on the EEOC. We'll expound upon it a little more here. So the EEOC is responsible for enforcing most EEO laws. So just think of the EEOC as the federal agency that is charged with actually, making this happen, law enforcement of this law, if you will. right? So the EEOC will investigate and resolve discrimination complaints. Um, they'll typically monitor organizations' hiring practices, and they collect and analyze what's called EEO-1 reports, and they're looking for things like unfair practices, discriminatory practices, so on and so forth. They also issue guidelines to help determine law violations. We also have what's called the OFCCP, the Office of Federal Contract Compliance Programs. Now, what this does is this enforces executive orders that cover companies doing business with the federal government. And as you can imagine, there are lots and lots of companies, right? Probably thousands or hundreds of thousands of companies doing business at varying levels with the federal government. So it audits government contractors to ensure they are actively pursuing goals in their affirmative action plans. The affirmative action plan must include a utilization analysis. Think about how people are utilized, where they're utilized, and what are the sort of the demographics of those people. Any goals and timetables, and then if need be, any action steps to like if there are any problems, if there are any issues that have come to light as part of the audit, action steps, and action steps could be from if they were audited previously, have they completed their action steps? If the audit is now like more recent, then the action steps would be, kind of moving forward, if you will. So avoiding discrimination. So one of the big things we worry about in the workplace is called disparate treatment. And this just means the differing treatment of individuals based on race, color, religion, sex, national origin, age, or disability status. So companies should evaluate interview questions and decision criteria to make sure they are job related and applied equally. So what they're kind of saying there is, like if you interviewing somebody for a job, you shouldn't be asking them about their religion, right? Their marital status. Well, what were you born here? So, stuff like that is not permissible. These are not things that you can ask somebody. It must be related to the job. Now, certain factors can be legal when there is a bona fide occupational qualification. And this is a necessary, not a preferred qualification for performing a job. So what they're saying there is, there may be times when there are questions that have to be asked relative to what you normally couldn't, because it's germane to getting that job and being able to do that job, for example. So avoiding discrimination. So we just talked a little bit about disparate impact. So again, this is a condition in which employment practices are seemingly neutral, yet disproportionately exclude a protected group from employment opportunities. So, just like if a company has a policy that, everybody is treated equally, but then you notice that 95% of the promotions go to, say, men, not women, or women and not men, then obviously that's a problem. Um, it isn't like, yeah, it isn't always intended by the employer. Sometimes these things happen, and then the EEOC may sort of audit them, step in and say, hey, we gotta fix that. They also often use what's called the four-fifths rule. We could say the 80% rule. So commonly used test of disparate impact in hiring practices. So if the hiring rate for minority groups is less than four-fifths the hiring rate for the majority group, then there is evidence. Now notice it says there's evidence of potential discrimination. It doesn't say discrimination, it says potential. So that's something that, of course, they would have to investigate further. That might provide a basis for an investigation, but there is certainly no finding there of discrimination. That's just something that, would kind of probably raise the EEOC's eyebrows and they would want to investigate further. Now, as far as avoiding discrimination goes, so employers can establish and enforce an EEO policy. This should define and prohibit unlawful behaviors and also provide procedures for making and investigating complaints. Now, as far as affirmative action and reverse discrimination goes, some argue that affirmative action is reverse discrimination. Fewer white males can be hired due to preference for women and minorities in hiring. Now, what most companies will do to sort of get past this is just always make sure that if they're hiring somebody, that's the best person for that job, the best qualified person, right? Their credentials are documented, their experience is documented, and that way, if a potential issue of discrimination comes up, then you should always be hiring obviously the best people for the job. So you say, okay, well, it may look like that, but if you look at this person's credentials, where they went to school, they have a license, they have some, more experience, so on and so forth, and that's what most companies would do. So a lot of it speaks to documentation. All right, let's talk a little bit about reasonable accommodations, because these are pervasive in the workplace. So employers are required to do something to enable all otherwise qualified individuals to perform the job. So religion and disabilities should be considered. So, somebody with disabilities could need like a ramp access or wheelchair access. If it's a religion, they may need a certain time of the year off or a certain day off. So, to the extent possible, those things would be accommodated. Now, the employer may be exempt from providing accommodations if it would require significant expense or difficulty. Okay, so as it says, the accommodation has to be reasonable in the sense that it doesn't impose an undue hardship on the employer. And the employers may perceive more hardship than what actually exists. So, of course, the employer is looking at, well, we have to spend any money, we don't really want to do that. So maybe we'll make it out like it's a bigger deal than it is to provide the accommodation, thinking maybe they can get out of it that way. Um, but again, there are ways companies can get out of these things if it would require significant expense or difficulty, and if such is able to be documented. But most times that's not going to be an issue. The companies are going to do it, and they're not going to want to, take on those potential legal problems. All right, preventing sexual harassment. So we could define sexual harassment as unwelcome advances, requests for sexual favors, and other verbal or physical contact could be considered sexual harassment when one, the submission is to conduct is a condition of employment. Submission or rejection is a basis for employment decisions, and conduct interferes with the employee's work performance. So that it doesn't, you wouldn't have to satisfy like all three of those, but if one of those was present, or maybe I should say one or more of those are present, then that could be potential sexual harassment. Different kinds of sexual harassment. Quid pro quo, which just literally just it's Latin, just means like this for that. Just like a boss asks for certain sexual favors in return for like a pay raise or a promotion. That would be an example of like again quid pro quo, this for that. Um, a hostile working environment where maybe people are always making like lewd jokes, and there are people that don't appreciate that. That could be considered a hostile working environment. So organizations can prevent sexual harassment by developing and communicating a policy that makes it clear sexual harassment will not be tolerated, and that behavior should be from the top down, like it isn't tolerated at any level of the organization. We should certainly train employees to recognize and avoid this behavior, um, providing means for employees to complain about harassment and be protected, and also acting promptly to discipline those involved. So I've actually talked about OSHA just a little bit earlier in the lecture, but let's just talk about it briefly again. Let's expound upon it a little more here. So OSHA, of course, is the Occupational Safety and Health Act. It was passed in 1970 in response to roughly 15,000 work-related fatalities that had been occurring every year. I mean, that is a staggering, astronomical number. So OSHA authorizes the government to establish and enforce occupational safety and health standards. Okay, and again, it's done through again, it's still OSHA, Occupational Safety and Health Administration. So these are, if you ever go into a company, you'll often see that poster, maybe in like a break room. So these are the folks that inspect companies for health and safety violations. And if there are, they'll levy fines. I mean, they could actually shut companies down depending on what, the level of severity. All right, general and specific duties. So the general duty clause says that employers must furnish each employee a place of employment free from hazards that cause or are likely to cause death or serious physical harm. So an example could be like a leaking pipe on the floor, where obviously somebody at some point is going to fall. That would be one example. Employers must also keep records of work-related injuries and illnesses and post an annual summary of them. Now, general and specific duties. So the employees have the right to request an inspection, have a representative present at an inspection, have dangerous substances identified. So think about like hazmat stuff, hazardous materials. That's what hazmat stands for. Be promptly informed about exposure to hazards and be given access to accurate records regarding exposure. And as we just said, have employer violations posted at the worksite. So these are all things, facets, components that employees have a right to in the workplace. Now, enforcement of OSHA. So OSHA will conduct inspections. A compliance officer will typically review the company's records. They'll do a walk around of the premises. They'll interview the employees, and they'll typically do a closing conference with the employer, and then they'll note any violations that they found. And then they'll typically give them a time period to correct any violations and pay fines. If they're not corrected, the fines will typically increase. So what has been the impact of OSHA? So it's certainly raised the level of awareness for occupational safety, but like safety in the workplace. I mean, think about that number, 15,000 every year, and I'm sure that number now is probably down to a fraction of that in a lot of parts thanks to OSHA. The combined rate of illnesses and injuries has decreased, which is a good thing. Increase in number of claims of retaliation against employees who report injuries. Workers are more aware of their rights, and of course now because of the proliferation of the internet, online tools, they're able to file their complaints online. And employee behavior is not directly regulated by OSHA, but will of course be considered. So if people are just constantly complaining about stuff that's really not a violation, then they're not really the employees not really going to do themselves any favors by doing that, because OSHA is going to be much more subjective, much more factual when they come in and they look for those types of violations. So that's just a little bit about OSHA. Again, when you get a job, or if you've got a job, you've probably seen that poster. They almost always post, typically in like a kitchen or a break room, because they're required to by law. So yeah, just a little bit about OSHA. All right, that's the end of this video. As always, thanks for watching, and I will see you in a future video.